event implicate Ms. Jiba or any other individual apart from the former president in any sense at all, and those are merely comments.
Well, you are of course not suggesting that what you mean is whatever it is you are going to refer to is something that has been said by the court and is in the public domain.
And all parties concerned have had an opportunity to present their versions, argue fully, and the result of all that process in the highest court is what I'm going to refer to.
Okay.
Chair, in addition to that, Mr. Sana himself raises a concern that he's here at some personal cost and at the request of the Commission, he didn't volunteer to come forward.
Yes.
And given that his evidence may now stretch over to another day, it's a matter of some concern, and I would just wish to place that on record. It was communicated to me during the recent short adjournment.
Yes, maybe before you proceed, let me talk to him. Mr. Mwasana, it appears that it's inevitable that you may have to come back. Now, Mr. Pretorius tells me that you are concerned about that. It doesn't mean you'll come back tomorrow, so you may have intended to spend only today at the Commission. But in terms of when you would come back, your availability would be looked at as well. Does your concern remain notwithstanding?
Yes, Chair, it remains, Chair, notwithstanding.
Yes.
Chair, as I have explained, that I run a practice.
Yes.
And unfortunately, I'm a sole proprietor of my practice.
Yes, yes.
My practice is suffering.
Yes.
As I am here.
Yes.
In fact, I've been here not only today.
Yes.
2 days.
Yes.
Already.
Including yesterday.
Including yesterday.
Yes.
Yes.
No,
and I see that it's inevitable and it's anticipated that I'll have to come back.
Yes. No, I think it's unfortunate that this is the situation, and I appreciate what you are talking about when you are a sole practitioner in a legal firm. When you are not there, you are not earning income, and there are people you have to pay at the end of the month. There are bills to be paid. But the legal team may have to have a look. I mean, if somebody goes to give evidence in court, there is provision for witness fees, and I would imagine that the Commission should have similar provisions that are applicable to it. I don't know what limits there are, but I would have imagined that they should be, their rate should be such that it should, as far as possible, place the person, the witness, in the position he or she would have been in if she had not been called to come and give evidence. But I think that probably at this stage there's nothing more one can say other than that that avenue should be explored. That might not fully cover your situation, but it might go to a certain point. Is that right?
That is correct, Chair.
Yes, I think that must be explored. I can see no reason why there wouldn't be a similar provision applicable to the Commission, but the legal team can look into that, and you can be in touch with them.
Thank you, Chair.
Okay. We look at the applicable law.
Yes, look at the applicable law. Yeah, thank you.
Thank you. Chair, the final matter is that Mr. Nkasana is booked on a flight at 7 o'clock, so if we may, because we're going to come back another day anyway,
Yes.
adjourn at the
At
normal
4.
time.
Yeah, no, that's fine.
Thank you.
So, one second, Mr. Pretorius. Can you ask them to also on the aircon just slightly? Thank you.
Thank you, Chair. Mr. Nkasana, at page 11 of your statement, you deal with the circumstances giving rise to your ultimate suspension by the President. For the moment, we're not going to deal with the evidence that you intended leading concerning the circumstances which you say it would have explained or would explain the President's actions, because those are matters which implicate other parties.
Yes. But just for correction, I wasn't ultimately suspended, just for the record.
Yes. Yes, there was an intention
There was an intention
to suspend, and that was the subject matter of litigation.
That is correct, yes.
Yes, I'm sorry if I put it that way. You also deal with the steps that you took to ensure that in any process that occurred in relation to your employment, you attempted to ensure that you would receive a fair hearing.
That is correct, Chair.
You deal with the inquiry that was intended to be held under Advocate Nazir Kasim.
That is correct.
We won't go into that for the moment, simply because I'd like to keep the evidence in its proper sequence. You then deal with the situation at the NPA during your term of office, which has been the subject of comment by the courts and concerns the conduct of persons who are implicated by your statement.
That is correct, Chair.
I'm not going to test the fine distinctions between what are facts within your knowledge that haven't been canvassed in court and what evidence has been canvassed in court. That's perhaps too fine a distinction to draw at this stage. So what I'd like to do is just to place on record, as is common knowledge, that you ultimately entered into what has been termed a settlement agreement.
That is correct, Chair.
That settlement agreement involved payment to you of a sum of money.
That is correct, Chair.
That issue came before the courts. And what came before the courts were not only the terms of the settlement agreement, but the fact of the settlement agreement, the circumstances in which it took place, and its lawfulness.
That is correct, Chair.
That litigation, of which you were a part but not the principal applicant, finally found its way to the Constitutional Court.
That is so.
And in a judgment of the Constitutional Court, which is contained in the bundle at page 85, the Constitutional Court dealt with the evidence placed before it.
1 second, Mr. Pretorius. Thank you. You may proceed.
The Constitutional Court dealt with the evidence that had been placed before it, dealt with the judgments of the courts below, and came to its own findings in relation to the issues before it, principally matters relevant to the National Prosecuting Authority and in particular relevant to the eventual ending of your term of office.
That is so, Chair.
And I'd like to go there directly, if I may, to deal with firstly some general comments made by the majority of the court under the hand of Madlanga J. Justice Madlanga. And if one can go to paragraph 6, the Constitutional Court in its majority there says, and that's at page, I'm sorry, Chair, that's at page 92 of the bundle, where the background is dealt with.
Thank you.
Paragraph 6 reads, the events that are at the center of these proceedings are in the public domain. The judgment of the High Court notes that it was common cause before that court that since September 2007, the recent history at the NPA, and it quotes the judgment of the High Court, has been one of paralyzing instability.
Yes.
That is the quote. That judgment gives detail of that history. If we may go then to paragraph 7, it reads, in July 2014, within about only 9 months of his appointment, a process calculated to remove Mr. Kasana from office commenced. That process would have been the substance of your evidence today,
That is correct.
in the main at least. The then President, the judgment continues, Mr. Jacob Zuma, informed Mr. Nkosana of his intention to institute an inquiry into his fitness to hold office. This was followed by a notice that the former President was considering suspending Mr. Nkosana pending finalization of the inquiry. The former President said that suspension was necessary in order to maintain the integrity and good administration of the NPA. Your evidence would have dealt with that contention in some detail because you, in your evidence, would have today and will in the future give evidence regarding what you regard as the true reasons for what occurred.
That is correct.
The notice also specified that the inquiry sought to establish whether certain issues were consonant with the conscientiousness and integrity of an incumbent in the office of the National Director of Public Prosecutions as required by the NPA Act. We've referred to that section of the Constitution already, Mr. Nkosana.
Yes.
The issues were Mr. Nkosana's previous criminal conviction for violent conduct, allegedly unbecoming and divisive comments which had the effect of bringing the NPA into disrepute, made by Mr. Nkosana and reported in the media, and alleged non-disclosure of facts and circumstances of prosecutions which Mr. Nkosana had faced previously. Now, in your evidence, you will go into some detail in regard to these issues, and in particular, the lack of particularity that you alleged in court proceedings you had been subjected to.
That is so.
And in fact, reference is made to that in the latter part of paragraph 8 on page 94 of the bundle, where the Constitutional Court says, Mr. Nkosana approached the High Court seeking an order compelling former President Zuma to provide the required particularity and interdicting the former President from suspending him until he had furnished him with this particularity. That particularity, Mr. Nkosana, is that to which we've just referred.
That is correct, Chair.
The application was not that application was not pursued to finality. The former President changed tack. In late 2014, he proposed that the dispute between him and Mr. Nkosana be mediated. Mr. Nkosana acceded to this proposal. Is that correct?
That is correct.
And then paragraph 9, which is on page 94 of the exhibit, EE, reads, it appears from a letter written on 10 December 2014 by attorneys acting for Mr. Nkosana that former President Zuma had engaged Mr. Nkosana to get him to agree to vacate office. In the letter, Mr. Nkosana made it plain that he did not want to vacate office as there was no basis for him to. He stated that he would, however, consider stepping down only if he was fully compensated for the remainder of the contract period. Is that a correct record of the facts as far as you're concerned? I'll give you an opportunity to expand on it in a moment.
Yes, that is a correct record.
At issue in the litigation, in part at least, was whether you had requested the former president to be allowed to vacate office, or whether you were compelled to vacate office against your will, but subject to certain conditions.
Chair,
If I hadn't put it correctly, it's now your opportunity to place the issues in dispute before the chair.
okay, thank you. Chair, at no stage did I make a request to vacate the office to the president, to the former president, Mr. Jacob Zuma. And that letter of the 10th, that is referred to here, I was also involved in drafting that letter, confirming the discussions that we had with the president in the company, and president and Mr. Hali, together with my legal representative. Therefore, the court found correctly that I did not make any request. I never made that request.
The position is summarized in paragraph 12 of the Constitutional Court judgment, and that appears at page 95 of Bundle EE, Exhibit EE. It reads, "It must be noted that right from the onset and throughout the entire negotiation process that culminated in the settlement agreement, Mr. Nkosana unequivocally stated that he did not wish to resign and that he considered himself to be fit for office. Instead, his preference was for former President Zuma's allegations that he was no longer fit for office to be tested in a formal inquiry as proposed by the former president." Is that the proposed Kasim inquiry?
That is correct, Chair.
The summary of the judgment continues, or the judgment continues rather. Throughout, he protested the existence of a factual or legal basis for him to vacate office. Also, he disavowed any invocation by him of Section 12, brackets 8 of the NPA Act to voluntarily vacate office. It is so, of course, that he did indicate that he would resign only if he was paid the full salary for the remainder of his term of office. Does that fairly summarize the position as far as you are aware?
That is correct. It fairly summarizes the position.
Then there are some general comments, Chair, which I think it is appropriate to place before you, because the evidence that will be led by the legal team deals pertinently with these issues, and these comments of the Constitutional Court are instructive and very important for the work of the Commission, and if I may place them on record.
Yes, you may do so.
At paragraph 18, the Constitutional Court says, "The importance of the office of NDPP in the administration of justice is underscored and amplified by no less an instrument than the Constitution itself. Section 1794 of the Constitution requires that there be national legislation which guarantees the independence of the prosecuting authority." Lower down the paragraph, it reads, "Section 1794 provides that national legislation must ensure that the NPA exercises its functions without fear, favor, or prejudice. That legislation is the NPA Act. Predictably, Section 32(1)A of the NPA Act requires members of the prosecuting authority to carry out their duties without fear, favor, or prejudice, and subject only to the Constitution and the law." Paragraph 19 reads, "This court has said of the NPA's independence," and it quotes there is a constitutional guarantee of independence, and any legislation or executive action inconsistent therewith would be subject to constitutional control by the courts. The reason why this guarantee of independence exists is not far to seek. The NPA plays a pivotal role in the administration of criminal justice. With a malleable, corrupt, or dysfunctional prosecuting authority, many criminals, especially those holding positions of influence, will rarely, if ever, answer for their criminal deeds. Equally, functionaries within that prosecuting authority may, as CASAC submitted, be, quote, pressured into pursuing prosecutions to advance a political agenda. All this is antithetical to the rule of law, a founding value of the Republic. Also, malleability, corruption, and dysfunctionality are at odds with the constitutional injunction of prosecuting without fear, favor, or prejudice. They are thus at variance with the constitutional requirement of the independence of the NPA. It continues, at the center of any functioning constitutional democracy is a well-functioning criminal justice system. In Democratic Alliance, Yaqub ADCJ observed that the office of the NDPP, quote, is located at the core of delivering criminal justice, unquote. If you subvert the criminal justice system, you subvert the rule of law and constitutional democracy itself. Unsurprisingly, the NPA Act proscribes improper interference with the performance of prosecutorial duties. Section 32(1)(b) provides, subject to the Constitution and this Act, no organ of state and no member or employee of an organ of state, nor any other person, shall improperly interfere with, hinder, or obstruct the prosecuting authority or any member thereof in the exercise, carrying out, or performance of its, his, or her powers, duties, and functions. And then the court makes some further comments relevant to your evidence, Mr. Nkosana, and generally relevant to the evidence that will be led and the concerns raised by this commission. At paragraph 21, which is on page 98 of Exhibit EE, it reads, improper interference may take any number of forms. Without purporting to be exhaustive, it may come as downright intimidation. It may consist in improper promises or inducements. It may take the form of corruptly influencing the decision-making or functioning of the NPA. All these forms and others are proscribed by an act that gets its authority to guarantee prosecutorial independence directly from the Constitution. Paragraph 22 reads, another guarantee of the NDPP's independence is provision for security of tenure. In Section 12(1), the NPA Act provides that the NDPP shall hold office for a 10-year non-renewable term of office. It is now well established in terms of this court's jurisprudence that security of tenure is an integral feature of the constitutional requirement of independence. In Justice Alliance, and the reference is given to that case, this court held that, quote, international standards acknowledge that guaranteed tenure and conditions of service adequately secured by law are amongst the conditions necessary to secure and promote the independence of judges. These necessary conditions must, of course, be true of the independence of the NPA as well. In a unanimous judgment in McBride, Bosiello AJ said that amongst the factors that are relevant to the independence of officers or institutions, which, in terms of constitutional prescripts, must be independent, are, and there is a quote from the judgment, the method of appointment, the method of reporting, disciplinary proceedings, and the method of removal from office and security of tenure. And we here dealing, Mr. Nkosana, in your case with the removal of yourself from office and the circumstances in which that took place and the lawfulness of that set of events. There is a further comment relevant to the previous comment in paragraph 23, which reads, The NPA Act has two other salient features that help shield the NPA from improper interference, namely the non-renewability of the 10-year term of office of the NDPP and certain safeguards on the removal of the NDPP from office. And then the various methods that are provided for termination of the office of the NDPP are dealt with. It goes on to say in paragraph 24 that the manner in which your office was vacated, Mr. Nkosana, was not constitutionally compliant, and you recorded in the judgment as having accepted that. Is that correct?
That is correct, yeah.
And then paragraph 25, certain salient comments are made concerning the conduct leading up to your vacation of office, and paragraph 25 reads, that is on page 100 of the judgment. The facts set out above point to one thing and one thing only. Former President Zuma was bent on getting rid of Mr. Nkosana by whatever means he could muster. His was an approach that kept on mutating. It was first a stick, then a carrot, a stick once more, and eventually a carrot. There was first the notification that Mr. Nkosana would be subjected to an inquiry with a view to establishing whether he was still a fit and proper person to hold office. Concomitantly, there was a threat of suspension pending finalization of the inquiry, albeit with full pay. This was followed by former President Zuma's proposal that there be mediation. When there was no progress on this, the inquiry was instituted. Whilst the inquiry was in its preliminary stages, the former president pursued a parallel process in which Mr. Nkosana was first offered, in a draft settlement agreement, 10 million rand. As indicated earlier, he did not accept it. What plainly evinces how desperate former President Zuma was to get rid of Mr. Nkosana is that this was followed by a draft settlement in which the amount was left blank. Mr. Nkosana was being told to pick whatever figure. Indeed, Mr. Hully said that he would, quote, await the final amount from Mr. Nkosana. And then the question is asked in paragraph 27. Instead of settling for so huge an amount, why did the former president not simply pursue the inquiry? Did he not believe that the evidence that had motivated him to come up with the idea of an inquiry was sufficiently cogent? If so, why did he not just abandon the inquiry and leave Mr. Nkosana in office? After all, he was exercising his powers as president and not involved in a personal dispute which he could settle as he pleased. It is difficult to comprehend why he would have settled on so huge an amount from public coffers to boot. Continues in paragraph 28, the inference is inescapable that he was effectively buying Mr. Nkosana out of office. In my book, conduct of that nature compromises the independence of the office of NDPP. It conduces to the removal of troublesome or otherwise unwanted NDPPs through buying them out of office by offering them obscenely huge amounts of money. Then, in addition to those comments, certain comments are made in regard to your own conduct in accepting the amount of the settlement. And I'll come to that in a moment, Mr. Nkosana, but as far as you know, is that a fair summary of the facts that were at least placed before, and I'm excluding any opinion now that may have emerged from the judgment. I'm just relating the facts.
Yes, it's a fair remark that is contained here.
I know that you are more empathic with the minority judgment,
yes,
which we will come to in a moment, and explain the differences. But your evidence then not only deals with the termination of your office as NDPP, but the real reasons that you allege existed which caused your office to be ended.
That is correct, Chair.
And that evidence would implicate certain
Certain
individuals,
individuals, yes.
and it is to those individuals that notice will be given, and in relation to whom you will give evidence in due course.
That is so, Chair.
But as I understand that evidence, it is such that there is an explanation for the conduct which led to the termination of your services.
That is correct, Chair.
I must put before you the comments of Justice Madlanga in paragraph 85 of the judgment. Those appear on page 123 of the bundle, Chair. In the latter part of paragraph 85, Justice Madlanga says the following: effectively, although Mr. Nkosana strongly protested his fitness for office, he was saying he was willing to be bought out of office if the price was right. As much as I sympathize with him, I do not think that is the reaction expected of the holder of so high and important an office the holder of which, if he or she is truly independent, is required to display utmost fortitude and resilience, even allowing for human frailties, because Mr. Nkosana is human after all. I do not think the holder of the office of NDPP could not reasonably have been expected to do better. His conduct leads me to the conclusion that a just and equitable remedy is not to allow him to return to office. Having decided, as the Constitutional Court did, that the termination of your services was unlawful, the further question arose in relation to which the majority and the minority disagreed.
Yes.
And that was whether you should be allowed to return to office. In fairness, you should be entitled to comment now that that evidence is on record, or that judgment is on record.
Yes. Chair. Are you asking me to comment?
Yes,
on it?
if you wish to.
Yes, thanks.
It's an adverse comment, and therefore, in fairness, you should be allowed
Yes.
to put
Thanks.
your own
Thanks for that.
opinion before the court, before the judge, or before the chair.
Firstly, Chair, as things were going on and that have been going on after I left office, I felt that had this matter come before the Constitutional Court, after this commission was constituted, and after the other commission of inquiry had been constituted, I strongly believe that the majority in the Constitutional Court would have come to a different conclusion. That is my view.
That is in relation to whether you should be reinstated or not.
That is correct, Chair.
Okay.
Perhaps
Not in regard to the main issue, in regard to remedy. In other words.
to the remedy, Chair, I felt that the...
Okay, I'm sorry, I may be confusing you.
Yes.
I just want to make sure that I understand where you locate your comments. You have just said that you felt or feel that had the Constitutional Court considered that matter after this commission and after the Mokgoro inquiry,
Yes.
they may have come to a different conclusion.
Yes,
So
that's my view.
I'm just asking whether the conclusion you are talking about is with regard to whether it should be reinstated or not, or are you talking about the main conclusion on the matter?
I believe that the conclusion would have been the same as the conclusion reached by the minority judgment, that I should be reinstated.
Okay.
If we have time, we'll get there in a moment. Just to place the judgment of the majority in proper context, its reasoning, at least in part, is in paragraph 87, which appears on page 124, bundle EE, exhibit EE, reads, "The narrative at the beginning of this judgment shows that for a few years there has been instability in the office of NDPP, and therefore in the leadership of the NPA. With a court challenge to Mr. Nkosana's vacation of office and to the appointment of Advocate Abrahams, that instability persists to this day." The second judgment, that's minority judgment, accepts correctly that it would be open to the President to initiate an inquiry into whether the manner in which Mr. Nkosana vacated office renders him unfit to hold office. The order proposed by the second judgment thus has the effect of prolonging the instability. The second judgment proposed that you should be allowed to return, or as a matter of law, that your contract should continue. In fact, that is the effect of the judgment.
Yes.
Relying on former president of the Labour Court reasoning that where a dismissal is invalid and unlawful, nothing needs to be done. The employment contract just continues. Zondo J.A., I think.
Well, there's never been a Zondo J.A. Yes.
President of the Labour Court.
Zondo J.P.
JP.
Okay, yes.
The order proposed by the second judgment thus has the effect of prolonging the instability. So it seems that part of the reasoning of the majority was that the instability, by allowing you to return, and the majority felt it had a discretion in that regard, which should be exercised in favor of the conclusion that you should not be allowed to return. The concern was one of stability at the NPA. And then one of the further results of the judgment of the Constitutional Court is that the appointment of Advocate Abrahams was declared invalid, and the President was directed to appoint a replacement for Advocate Sean Abrahams.
Yes.
If I may then just briefly go to the order. You were ordered then to repay the amount received by yourself less tax. Is that correct?
That is correct, Chair.
And then in the minority judgment, after a long debate over the consequences of a declaration of invalidity in regard to termination of an employment contract, the conclusion is reached at paragraph 112 by the minority, which is at page 134 of the bundle, Chair, where Justice Jafta stated, "In the present matter, there is nothing exceptional or extraordinary that warrants the exercise of remedial power to prevent Mr. Nkosana from returning to office. His return will certainly not cause a constitutional crisis or a national crisis. On the contrary, his return would enable the President to follow the law if he wishes to remove him from office, and Parliament would play a vital part in that process. And more importantly, preventing Mr. Nkosana from returning to office without pronouncing on the validity of his employment contract would not only be unfair to him, but would also create considerable uncertainty on the parties' rights and interest. This would be antithetical to the rule of law, which promotes certainty." And in relation to a just and equitable order, the court found at paragraph 128 in the minority, page 140, as mentioned, allowing Mr. Nkosana to go back to his job would also meet the objects of the Constitution and the rule of law. If his involvement in the impugned settlement agreement brought his fitness to hold office into question, he may be removed in Section 12 of the NPA Act. For all these reasons, says the minority, I do not support the conclusion that Mr. Nkosana ought not to resume office following the setting aside of the invalid and unlawful termination of his appointment. That is, in summary, what the Constitutional Court found after all the evidence had been placed before it, had been considered by the lower courts, and was finally considered by it, and we all know the result. What remains is for your evidence to clarify the circumstances which led to steps being taken to remove you from office, and those will be the subject of the further evidence of Mr. Nkosana. Is this a convenient time, Chair?
Yes, it is subject to just mentioning that the last part that you talked about in regard to the judgment comes from the minority judgment.
Yes.
And what you said at the end might be misunderstood as if you're saying that's what the court said, but what you intended is to say some of the things you have said come from the majority judgment, and the last bit comes from the minority judgment.
Yes, the last quotes were all from the minority judgment.
Yes. Okay, yes, we can adjourn now. So, Mr. Nkosana will adjourn, and it's on the basis that you will be asked to come back, and the legal team and yourself liaise with them with regard to what witness fees or what fees may be payable when a witness has come to the commission and because of that is not able to work and earn income. For somebody who is self-employed, it's quite important. I'm hopeful that there is a provision that should take care of that. But you will be asked to come back.
Thank you, Chair. I will.
Yes, but other than that, thank you for availing yourself, and then arrangements will be made as to when you will come back, and the legal team of the commission will make sure that implicated persons are given Rule 33 notices.
I might just add, Chair, that the Commissions Act under which we operate was passed at the time that the currency was still in pounds, so that may favor them.
Yeah, so he might prefer that the remuneration be in the currency stipulated in the Commissions Act of 1947.
I think the Interpretation Act may have something to say about that, but we can examine it.
Yes. No, thank you very much once again. You are excused.
Thank you, Chair.
We adjourn. And tomorrow we'll start at, what time should we start?
9:30, it's the aviation
Yes.
stream of evidence, and I think I mentioned to you, Chair, the start time of 9:30
Yeah, we'll
throughout
start,
the aviation.
We'll start at
stream.
9:30 tomorrow morning. We adjourn.
Thank you.
It's like 30 minutes from now.
Oh, yeah. And then I did office there. Continue. Say half an hour lah. Oh, then I got up.
And besides, at 5 o'clock they have Aaron and Stevie.
So you can't call it corrupt and arrange and top of that.
lwenkxaso.
Need a pen?
Oh, yeah, yeah, yeah.